We've been following Measure 114 closely since the days and weeks before Election Day and ever since, and we know this story is probably going to go on for a long time. In fact, we're so confident that we asked one of our talented editors to make us that special animation you just saw. Pretty cool, huh? Not that we're trying to glorify guns or anything else. We just had to see that one more time because we think it's cool. Anyway, several legal challenges stand in front of Measure 114 on the federal and state level, but right now it's the state lawsuit that has 114 paused. And to be clear, no part of 114 is in effect. Right now, gun laws in Oregon are exactly the same as what they were before Election Day. The permit process to buy a gun that 114 requires is on hold, and it's going to stay that way until the state says the process is ready to go. That likely won't be very soon. And even after the process is ready, that element of the measure has to make its way through the courts to decide if it's constitutional. But forget that for a moment. Let's get to the latest ruling by the Harney County judge. This week, Judge Robert Raccio heard arguments on the part of 114 that bans magazines that hold more than 10 rounds. Plaintiffs, those are the folks who are against 114, they asked for an injunction or a pause on that part of the measure until the courts can decide if it violates the state constitution. Long story short, the judge said, yeah, that's a good point you make. You can have your injunction. Now, let's look deeper into the judge's ruling and reasoning on this. And by the way, no, we can't get to every single point. It's a 25-page ruling. Go read it yourself. But we are going to highlight a few. And remember, this case is focused on the measure's constitutionality based on the state constitution. This is not about the Second Amendment of the U.S. Constitution. All right, here we go. Here's the exact wording of the state constitution in question, specifically Article 1, Section 27, right to bear arms, military subordinate to civil power. The people shall have the right to bear arms for the defense of themselves and the state, but the military shall be kept in strict subordination to the civil power. Pretty short, that's the whole thing. The judge wrote that in looking at the historical background of the state constitution and state law, case law surrounding it, the defendants, those are the people who want Measure 114 to become law, well, the judge says they're wrong to argue that the state constitution was written at a time before high-capacity magazines were in use. He wrote, the plaintiffs, those again are the folks trying to block 114, they demonstrate that firearms with magazines capable of over 10 rounds of ammunition were in existence at the adoption of the Oregon Constitution in 1857. Article 1, Section 27 was adopted without any noted debate by the delegates. The court infers that from silent record that no concerns were raised over the types of firearms allowed for self or state defense. The analysis of this court is that the framers and the population were aware of and even anticipating more powerful firearms, including with larger magazine capacities. As such, he goes on, the court finds that the firearms today are the direct descendants of the firearms from the time frame of statehood, multi-shot handguns and rifles. The type of magazine is essential to the protective power of the firearm, as was testified to by one of the defendant's witnesses. So the judge is saying, look, the argument that high-capacity magazines were not around when the state constitution was written and therefore we can ban them, he says that argument is not accurate. The next issue that he took up, and this is again from the defendants, those are the folks supporting the law, well, they're arguing that banning high-capacity magazines would eliminate a grave risk to Oregon citizens, basically the risk of getting shot. So on that point, the judge wrote simply, the facts do not support their conclusion. But he went on to say that the state constitution allows for reasonable restrictions to promote public safety. However, in his view, the evidence presented to him does not add up, writing that the large capacity magazine bans promote public safety is mere speculation, does not restrain dangerous practices or regulate the carrying or use of firearms, only the possession of a ubiquitous weapon design. Supporters of the law argue the high-capacity ban would reduce mass shootings, but the judge says the sample size of the study presented in court is just too small to really say that it's definitive. By the way, that study looked at 604 mass shootings. It concluded it seems like large-capacity magazine bans reduce mass shootings, but the judge argued that there's no scientific certainty that a ban like that would have an impact on fatalities and casualties. The judge also said that data supports the idea that a ban like this would be unduly burdensome on Oregonians. He pointed out that roughly 20% of Oregonians own a gun and that Measure 114 would have an immediate impact on the liberty interests of those gun owners and, quote, make it harder for the weaker individuals in our society to defend themselves against attackers. He also said about 5% currently own high-capacity magazines and that they would be presumed guilty of a Class A misdemeanor unless they can prove otherwise, basically saying they would need a receipt or something like that showing that they had it before the law took effect. Now, another point the judge made, and this is the last one we'll highlight tonight, is that any gun magazine could be made to hold more than 10 rounds. And because of that, any and every gun magazine would be illegal under the new law, which essentially would make guns illegal. And that violates the state's constitution. But the judge's opinion is that we shared is only for the injunction here that we're talking about. There's going to be more hearings to determine whether or not the magazine ban actually violates the state constitution. I know it's complicated and convoluted, but that's the law. There's one more part to 114 to keep in mind as well. The measure has a so-called severability clause. So that means if the court finds that one part of the measure is unconstitutional, well, it could just drop away and the rest of the measure would still remain in place. Each part of 114 eventually will have to be weighed for constitutionality to determine when, if at all, any part of it takes effect. And according to one law professor that we talked to at Willamette University's College of Law, that could take a while.
I think it's inevitable that the Oregon Supreme Court will be asked to decide this, but that's probably years away.
So, get ready for that. The next update we expect from Measure 114 is going to come on Friday, December 23rd. That's when a hearing is scheduled for the judge to consider arguments about the so-called Charleston loophole that 114 would close if enacted. That loophole means if you've been waiting longer than 3 days for a background check to be finished after you're trying to buy a gun, that the gun dealer can legally give you that gun after those 3 days, even if the background check is not done. 114 would not allow them to release the gun to you until the background check is finished. The judge's ruling on that is expected in the first week of 2023. What do you think about all this? We'd love to hear your thoughts about the latest with Measure 114. What do you think of the judge's opinion about the high-capacity magazine ban? Did he change your mind? Let us know. Send us an email. Our address is thestory@kgw.com, or you could call and leave a voicemail, 503-226-5090.